Okay. All right. So this is laws 13013, legal professional conduct. This is week 4, the first part of the tutorials for this week, looking at costs and liens, and we're looking at problems 12 through to 16. So what I'll do now is I'll just skip over to the actual subject's site so that we can have the problems up there. Here we are, that's it, screen share. All right, so just zooming down. Oh, by the way, there's a film competition if people are interested. It just so happens that it's a short film, but to create a film, you have to create a script, and you're all creating scripts. And this year, the film competition's on ethics. So if anybody's interested, they could work to turn their script into a film. That can be an animation, it can be a normal movie, whatever you might be interested in. So there's something there that you could do with your script. Okay, so just going down here to the actual problems. Problem 12 is the first one, and it asks, what is the extent of the legal practitioner's obligation to disclose how their costs are calculated? And then the second part of the question, what are the implications of non-disclosure of costs or estimated costs? So, anybody got an opinion on what is the duty, or where do we find the duty of disclosure in relation to costs? Anybody found that?
Steve and I had it was section 308.
Yes, that's right. Section 308 of the Legal Profession Act 2007. And what sorts of things does that provision require solicitors to do?
Set out the basis of which the legal costs are to be costed out, the negotiations for cost agreements, with the ability to receive a bill, itemised bill, under those, continues on then, rate of interest, any substantial change, estimates, etc.
Yeah, it's quite a detailed provision, isn't it? When you have a look at it, there's a lot of things that you have to discuss with your client when you're setting up the retainer in terms of costs. And they're all set out in section 308, and it's reasonably uniform across the country. So if you go to New South Wales or Victoria, they also have these types of provisions. And the Queensland Law Society has a booklet that explains in a lot more detail the sorts of things that you have to do, and it also gives you some pro forma examples of what these what this document would look like. And what I'll try and do, I've got to get permission from the Law Society to be able to show you their document, but I'll get that, but it'll just take me a little bit of time. I was having a look today and I came across it. It's only just come out in 2014. But just to give you an indication of what's in that booklet, I'll stop the share. I'll just switch over to this booklet so you can get an idea. So you can see it's a cost guide, and this is version 1 for 2014. When you actually have a look in it, it's got a lot of the details. It has an overview, but then it's got all the requirements for retainers and costs agreements, and it's quite comprehensive. So this is something that you could certainly reference for this course, but it'll also be something that you'll need for the practical legal training courses eventually that you'll do. And one of the things I noticed about this is that actually when you skip down to the end of it, it's got these examples of what the documents look like that you would give to your client as part of this process of setting up the retainer. So I think for our purposes today, the main idea is for you to realise that Section 308 is the provision in the Legal Profession Act that governs this. It has a lot of detailed requirements, and you should have a good look at those, because typically what happens is that if I ask a question on this, and I don't know whether I will or not because I haven't said any exams or problems yet, I could set up a list of facts and then ask whether that's a sufficient retainer, or is there some problem, or what's the nature of a problem with a costs agreement. So you need to know those provisions. Some of the other things that you should note is that they're expressed in writing, and they have to be in plain English, not in lawyer speak, if we put it that way. So it's got to be in a language that the clients can deal with. And in terms of when it has to be done, it has to be done as soon as practicable after the law practice is retained in a matter. Okay, so as soon as that retainer contract arises, then this cost agreement needs to be put in place. And there's a continuing disclosure obligation. So it's not just when you initially set up the cost agreement, there's an obligation to continually advise if there's changes in circumstances that are going to affect the nature or calculation of costs. So the whole idea is that the client is fully aware of what the matter is costing them on an ongoing basis. If you're charging on any sort of unusual basis, like, for example, you might be charging an hourly rate notwithstanding the qualifications or experience of a particular lawyer. So you can sometimes see this where they might charge a partner's rate, but it's actually the work's done by a paralegal or done by a junior lawyer. So there's things like that need to be disclosed. That would be an unusual thing. It's not unheard of, but it'd be unusual. It would need to be disclosed. So that's an example of that. In terms of exemptions, not every matter requires a cost agreement. There are some exceptions. Does anybody know what some of the exceptions are? Did you come across any of the exemptions? They're in section 311.
Where the costs are less than $750.
That's right. And what are the other ones? There's a few more.
Yeah. Where the client is a lawyer.
Yep. Public company or a liquidator. In other words, somebody who's used to these sorts of processes. The other one is if the client has been given one of these disclosures within the previous 12 months. So what it's looking at is the experience of the client. So if they've got a reasonable amount of experience with these things, then there are exemptions. The other one's $750 because
that
it costs. Yeah, go on.
Is it that disclosure in the previous 12 months? That's from that same legal firm, not from another one.
I don't think it actually specifies that. Look, I think the answer to that really is best practice would be to make that disclosure in any event. The only one that's a little bit more problematic is this one where it costs less than $750 because there is a cost in making these agreements. But at the end of the day, if you're a large, if you've been in business a while, you're going to have standard documents that you're going to create and that you're going to give to the client as part of creating the retainer. And I think best practice would be to make sure that your client, that, they've got all of this information anyway. So while there's some exemptions, it's probably better to do it anyway. What happens if you don't do it? If you're the law firm and you don't actually give proper disclosure of costs or estimated costs, what's the consequence of that?
That the client need not pay the costs and the solicitor cannot attempt to recover?
It's sort of almost right. That's most of it, but does that prevent the law firm from ever recovering those costs? The law firm can do something, can't it, to get those costs? What is, have a look around section 316. Doesn't it say that the lawyer can't maintain proceedings to recover those costs unless a cost assessor has assessed the costs? So you could send it out to a cost assessor who's an independent person whose job is to assess costs, and there are cost assessing firms. And if they then make an assessment, then there's a whole lot of rules surrounding whether the costs originally charged are a certain percentage above or below what the normal costs are or should be. So say, for example, if the costs are, for argument's sake, after they're assessed, 20% lower than the bill that the solicitor gave, then what you can find out, what the result of that is that the client has an obligation to pay the lower costs, but they avoid having to pay the costs of the cost assessor because they charge costs to actually assess costs. So it's a bit of a vicious circle. So you can still recover your costs, except it will require the assessment of costs, which will cost money. As I say, there's a whole business surrounding assessment of costs. It's an expensive process. But if you've got a solicitor who's overcharging, it's worthwhile for a client to go down that route with another solicitor. Okay. Now, the other aspect of this is not so much in terms of whether the solicitor recovers their costs. There's another twist to this, which is far greater impact on the solicitor. Does anybody know?
Unprofessional conduct.
That's right. It could be a situation where there is an allegation that might be able to be substantiated of unsatisfactory professional conduct or professional misconduct. Now, just be really wary of those terms because when you're reading through your textbook, they're expressed differently in different states. So the terminology is unsatisfactory professional conduct, which is the lower level one, or professional misconduct. And that's what you'll be looking at when you're looking at, I think you're in this week, looking at problems with relation to misconduct. Okay. All right. So that's the basic gist of what's required. All right. So we'll stop sharing. I'll try and get you that cost guide if I can. I just got to get permission from the Law Society. All right. Let's move on, and we'll shift over to the next question, which, just go back, problem 13. Okay, problem 13. Okay, cost agreement allow for contingency fees, outline the statutory limits imposed on cost agreements of this type and discuss the advantages and disadvantages of this approach. Okay, well, what is a contingency fee, I suppose, is what we should ask first. What's a contingency fee? Anybody know? No? You're all gone quiet. Okay, all right. Well, look, it's contingent on something. So it's contingent essentially on success. So what the contingency is that some or all of the lawyer's costs is conditional on the successful outcome of a particular matter. So that's known as a conditional cost agreement. Okay? So some or all of the lawyer's cost is conditional on the outcome of a particular matter. Now, this is different from a contingency fee arrangement. So a conditional costs agreement, which is permissible under the rule, under the actual Act, Section 323, Legal Profession Act 2007, Section 323, that is different from a contingency fee. What's a contingency fee? You see these in America, essentially. Yeah, go on, Luke.
Would it be that, the more you win, the more I make?
It is. So your percentage recovery as a lawyer is some percentage of the total judgment that's received. So it's based on the judgment. It's not, so basically what you're saying is that you are prepared to pay the costs or some percentage of the costs involved in running the matter, but your payment is based on a percentage of what can be recovered from the action. That's different from a conditional costs agreement whereby the lawyer is allowed a percentage lift in the fees that they can charge, dependent on the outcome of the matter. So one's related, the prohibited one, the American-style contingency fee, is based on the amount recovered overall, whereas the conditional costs agreement, it's still contingent on whether you win or not, but it's a percentage increase on your standard fees and charge, your standard fees essentially, under the scales of costs. So it's much more limited than the American-style situation. And in fact, if you try to do a contingency fee situation in Queensland as a lawyer, it's a 100 penalty unit fine, or up to a 100 penalty unit fine. And a penalty unit is worth $110. So you're basically up, it could be up to a fine of just over $10,000 if you go that way. Okay, so are you clear on the distinction? There's two types of situations. All right. If you're looking at a conditional costs agreement under Section 323, the one that's permissible, it is required that the agreement is very clear and it sets out what are the circumstances in which you can define success in the particular matter. And you're allowed an uplift premium of up to 25%. You can't get more than 25% on a conditional costs agreement. Okay? Whereas with a contingency fee type arrangement, if it was permitted for a lawyer to do that in Queensland, you could charge whatever percentage you wanted to. Okay. All right. So you know that there's a penalty. It's a 100 penalty and a fine under Section 325. So what are the advantages, do you think, in having this conditional costs agreement? Why has it been allowed to happen under the rules? What are the advantages of it?
I think one was just assisting clients where they didn't have to pay upfront fees.
That's right. Now, that's important, what you've said there in relation to fees, because generally it's in relation to fees, okay, but not disbursements. So you get other sorts of disbursements like the payment of court costs, the payment of barristers' costs. What we're talking about in terms of fees are the solicitors' fees for charging for their work. That's what's looked at in terms of this. Okay, so it does increase access to justice by enabling people who can't afford to pursue a claim to utilise this as a way of funding their litigation. What's another way they could fund litigation? How are big class actions funded? Does anybody know? We've got some really big examples of class actions going on at the moment, or about to start. There are actually companies that fund litigation. So if they're not law firms but they're financiers, they're not subject to the same rules under the Legal Profession Act that affect the lawyers, so they can charge higher percentages. They sort of run on a very fine line. There used to be an old tort of championing and another one of maintenance, and so that is promoting and funding litigation used to be a tort against that, but now there's a whole industry that's grown around funding litigation. So one way of looking at these uplift fees under the rules is it's a way for lawyers to actually compete against these other businesses that fund litigation. Okay, so there are some advantages. What are the disadvantages? What can you see as some of the disadvantages?
I think one of those ones was where lawyers could push for an early settlement.
Yeah, why would they do that?
Well, there's not a lot of reward coming their way if the case was extended out over a period of time.
Well, that's right. And also they avoid the risk of losing, don't they? So if you can settle a matter earlier, you still get your percentage uplift of your costs, but you get the money earlier and you avoid the risk of, potentially, whatever the risk may be, of actually failing in the action. So there's a big incentive to try and turn over matters quickly and recover those fees. So that's a disadvantage. Any other disadvantages? There's a problem with, you've got to be really careful about how success is defined. I mentioned this earlier. It's really important to have a very clear picture of how success is defined so you don't end up having further litigation over the meaning of the costs agreement. You can have situations where people maybe have been successful. They then feel that they've paid too much to their lawyer to obtain that success. So they then start to try and unravel the costs agreement. So they hire another set of lawyers to dispute the terms in the costs agreement. So, there's a whole, you can have a situation where there's a series of litigation related to this particular matter. All right, so look, the objective of this was really to do a couple of things. One was to make sure you understood the difference between contingency fees and the conditional costs agreement, which are permissible under our particular piece of legislation for solicitors, and that you also understood some of the advantages and the disadvantages of having the conditional cost agreement. So that was the objective of that particular question. There's a bit more detail to all of this, but and I'll put that up on the Moodle site for you. All right, well, we'll move on. We'll have a look at problem 14. Zip down to problem 14. Where are we? Problem 14. Okay, so here we have it. In 2004, Sally was involved in a motor vehicle accident with John. John's negligently ran a red light, resulting in a collision with Sally's vehicle. She suffered personal injuries, resulting in a claim for $250,000. The judge ultimately awarded her $150,000 on the basis there was 2/5 contributory negligence in Sally's failure to keep a proper lookout. So what that means is that the judge is saying that while the personal injury resulted in a claim of $250,000, the defendant in this matter can't be entirely held responsible for that amount. The reason is that the plaintiff contributed to the actual, they were also negligent. It contributed to the accident. So their award of damages is reduced by the extent of their contributory negligence. Okay, so she's in effect getting 3/5 of the actual judgment. The other 2/5 she's not entitled to because she contributed that negligent. She was negligent, which resulted in that apportionment. The next thing that happens is Sally's solicitor charged $5,000 to prepare the case. The barrister, junior counsel, charged $1,800 per day of the 2-day court case, including a $200 allowance for drafting the pleadings and preparing the case. Sally's case involved presenting 2 experts' medical testimony and accompanying reports. The report costs were $500, $1,500 respectively. Witness fees for $2,000 and $3,000. Sally's solicitor maintains that the scale was contracted out of. Okay, so when it refers to a scale, what that is a scale of costs. And you'll see more about scales of costs when you do civil procedure, but scales of costs are essentially a way in which the legislature has tried to limit the extent of legal costs. So they will say that, for example, for a particular letter, you're entitled to charge X number of dollars. And it's really quite detailed as to those costs. So when people prepare an itemised bill of costs, they prepare that in relation to what can be claimed under the scale. When that is then, if it is then assessed by a cost assessor, the cost assessor will look at those items that are claimed as a cost by the solicitor as against the scale. And if the item can't be claimed under the scale, they will what they call tax it off. They will cross it off the bill, which means that the client doesn't need to pay that. So scales of costs are important because they're like a method by which to judge whether you're entitled to particular costs or not. It doesn't... Yep. Go on, Margaret.
Who sets the scale of costs?
It's set by the regulations. So effectively it's set by the government. That's not to say that solicitors and barristers can't charge more than the scale, just in the same way that doctors can charge more than, the Medicare or recommended fee. So they can charge above the scale. But, you got to make it very clear in the costs agreement the basis on which charging is occurring. And if it's quite clear that they're going to charge more than the scale, then that needs to be in the document, in the costs agreement. And that's what's happened here. See, Sally's solicitor's saying that the scale was contracted out of. In other words, they have a costs agreement which enables higher fees. Sally acknowledges that while she signed the written costs agreement, she denies the solicitor gave prior separate written notice that she was liable for the gap between party and party recovery and practitioner's own costs. Now, what that means is that there's party and party costs, or in other words, what they call standard costs, are the ones permitted by the scale. Practitioner's own costs, they're the costs that the practitioner is charging, which may be above the scale. Okay? It's sometimes called practitioner's and own client costs as well, similar sort of terminology. So there's a dispute arising here between Sally and her solicitor. The solicitor is anticipating being paid their full, the full costs under the costs agreement. Sally's arguing that she's not liable for the difference between what the standard costs are and what the solicitor's actually charged. So there's a dispute about the costs agreement. So Sally also notes no stamp duty was paid on the costs agreement. Okay, so she's arguing there that this costs agreement is a contract and that such contract is subject to stamp duty. And if stamp duty is not paid, then the contract becomes unenforceable because it's void. Essentially, it's illegal because it hasn't had the stamp duty paid on it. So that's her argument. Now, this is a hard problem. It's got difficult issues in it. It's there just to show you a little bit more complexity in some of these things. I don't expect you to have knowledge of the Stamp Act. I don't expect you to have detailed knowledge of all aspects of costs because it's quite a big field. But I just wanted, with these problems, to give you a bit of a flavour of what some of the issues that can arise. So Sally's now received a bill of costs from her solicitor outlining all these costs. So she's got an itemised bill. And advise Sally how she can contest the bill of costs and what objections she can validly make. So, does anybody want to have a go at that? It's a bit of a difficult one, and there's actually differences between the different states on how you'd answer this as well. Did anybody have a go? No? No? All right, look, in Queensland, there's no provisions with respect to motor vehicle claims fixing the practitioner's charges. There's the Motor Vehicle Insurance Act 1994, Section 55. That can limit cost awards, but only in cases involving very small awards of damages. But it doesn't restrict the practitioner's charging. So it's a bit different in Queensland compared to New South Wales. New South Wales is more highly regulated in this area, and what I'll do is in the answer I'll pop into the comparison with what the situation in New South Wales is, where it's really highly regulated. So what essentially this then comes down to is that the solicitor, and it doesn't matter whether in Queensland or New South Wales, they still have to make disclosure of what the costs are under Section 308, which is what we've looked at in the previous few questions. That disclosure or that costs agreement has to be in writing. It has to be in plain English. And essentially what we've got, it's there's no dispute as to the outcome of the case. What there is a dispute as to the terms of the cost agreement and whether it's been honoured or not. There is an issue about stamp duty, which we've mentioned. If you want to enforce a contract that's subject to stamp duty, you have to pay the stamp duty. Otherwise, it's unenforceable. So what could happen is that the matter could be delayed until stamp duty is paid. So what will happen is most likely Sally, since she's objecting to the itemised bill, what she's going to do is to seek to have it assessed by a cost assessor. So she wants to get an independent person to come along and say whether these costs that the solicitors listed in their bill, now a bill is just a list of the charges that they're claiming, whether they're valid or not. And she's entitled to dispute the bill under Part 3.4, Division 7 of the rules. And that's what she would do. The other thing she could do is to challenge the whole costs agreement itself under Section 328 on the basis that there's been inadequate disclosure. Okay, so that's really what that question's getting at. So in terms of, as I say, that's a fairly hard question, but that's how you'd approach it. Okay. All right. Well, we'll keep going. The following ones are a bit easier than that one. Problem 15. That's me. Where are we? Problem 15. Okay, Paul Lux and Associates Solicitors regularly advertises in local newspapers that they are prepared to take on clients on a no-win, no-fee basis. And you see these ads all the time. Okay. Julian, in his hospital bed, reads the advertisement and contacts Paul. Okay, Paul from Paul Lux and Associates Solicitors. Paul then visits Julian and outlines that he will accept Julian as a client on the basis that Julian will have no outlays at all. But when they win or settle the case, Paul will be entitled to 25% of the amount recovered. Okay, what type of agreement is that? Is that a contingency fee or is that a conditional costs agreement?
A contingency fee basis.
It's a contingency fee. And is that allowed?
No, that's not permissible. No,
it's not permissible. There's a 100 penalty unit fine for doing that. Okay, so it goes beyond the no-win, no-fee arrangements that are permitted under Section 324 of the Legal Profession Act. It goes beyond those uplift arrangements to an American-style contingency fee, which is prohibited under Section 325. Okay, all right. And that's essentially it. What's the net effect of it then? Because there has been an agreement entered into. It's subject to a fine. It could be subject to a situation where Paul could be up for unsatisfactory professional conduct or professional misconduct. But is the agreement itself still a valid contract? Remember, it's a retainer contract.
No, it'd be rendered void.
Okay, that's right. But what's the provision?
327.
327. So in your answer, always make sure that you state what the proposition is. You'll say that this agreement will be rendered void under Section 327 of the Legal Profession Act 2007. And that's actually, just on that point, that's one of the things I noticed with a lot of the answers that people have been posting up on the site. They just don't have that extra, some do, but most don't have that extra degree of detail of saying what the point is, what the relevant law is, what the section or case, including the case citation is for whatever the point they're arguing. And that's what you look for in a better answer, a very structured answer, but with the detail. And that's how people do really well, and not just in this, any subject, any law subject, and even when you get out into practice as well. You've got to be very clear about what your argument is. Okay, so that's really all that was in that question. So that one's fairly straightforward. Okay, so the next one is problem 16. So problem 16, I'll just run down there. Where are we? Problem 16. Okay, so here we have it. So Trevor, a fashion model, entered into a contract with a well-known sportswear label to promote its products at a number of football matches during the 2012 season. Partway through the term of the contract, Trevor received an offer to take on an acting role in a new television program, Fathers and Sons. A few months later, Trevor received a letter of demand from the solicitor of the sportswear company claiming that it's breached the contract, demanding damages of $50,000, being the estimated loss of sales. Trevor consulted Trapp's Law Associates and is interviewed by their first-year employee solicitor, Belinda Gray. Belinda reads the letter and advises that it was unlikely that the sportswear company would take action, as it would not want any bad publicity seeing Trevor had become a household name in the new soap. Belinda advised him to ignore the demand. Now, looking at that, where does the retainer start and has it ended? What do you think? Just in terms of defining where the contract, the retainer contract arises and whether it's ended. What do you think?
But no, she did give him advice.
She did. That's true. So there must have been a retainer, a situation where a retainer has arisen when he goes to see her. She's giving the advice.
But it's not written down.
No, there's all sorts of problems with it, isn't there? There's no costs agreement mentioned. It's a very vague sort of situation. It's also vague as to when it ends. Has it ended because she's advised him to ignore the demand? He's then gone away. Is that the end of the retainer agreement? So these are the things, this is where people become unstuck with these sorts of arrangements. If they're not crystal clear when the agreement arises, what the terms of it are, and how it completes, then debates start to arise as to whether the retainer contract's still in existence. See, what happens then is that you're told a month later, Trevor received a summons from the sportswear company solicitor claiming $50,000 damages and legal costs. Trevor once again met Belinda and stated that he was unhappy with her initial advice and wanted to know what she was going to do about it. Belinda stated that she would defend the claim and give him a discount of 20% off the firm's normal fees. Okay. Can she give a discount? Can a law firm give a discount? We've been talking up to this point about how they can have uplifts. Can they give discounts? What do you think?
I thought maybe they could, but I didn't think she was in a position to be able to make that decision. She's a first-year employee.
I think that's exactly right. That's right. So law firms can give discounts on their fees. That's fine. But you're absolutely right. She's not really in a position to make that judgment call, is she? I suspect she wouldn't last very long in her law firm if she did that. So she would need to talk to a partner about that sort of arrangement. Okay, so now what's happened next is that Trevor was given the firm's standard cost agreement. Finally, the cost agreement has arisen. And he signs it without reading it. Not a good practice. Okay. Belinda stated she would contact him after filing his statement of defence. Month later, so another month goes by, Trevor receives a notice that judgment's been entered against him. He discovered that no defence had been filed prior to the hearing, so there's probably been a default in delivering a defence. He was now faced with having to pay $50,000 in damages, $2,500 legal costs, and he calls Belinda several times and leaves messages for her to call him. A week then passes. She calls him and states that she was making every effort to have the judgment set aside and for him to defend the claim. Now, you can set aside default judgments. Delay is a factor that operates against you, and you'll do that in civil procedure. A week later, she informs him that she's been unsuccessful, so she didn't get anywhere doing that, but says that she's negotiated with the other party's lawyer that he had to pay $50,000 only. So even though they've got a default judgment for $50,000 plus another $2,500 legal costs, presumably there are also further costs arising from her trying to set aside the default judgment, because that would require an argument in court. She's then negotiated a settlement, in effect, where he just pays the $50,000 instead of all the, ever-increasing costs associated with what she's been up to. Okay, Trevor, not surprisingly, is completely dissatisfied. Belinda then tells him that she'll try and seek a further reduction. So she's then going off to try and negotiate a settlement that's more favourable to Trevor. Next thing that happens is that Trevor receives an account or a bill from Trapp's law associates for $3,500. So he's really happy now, isn't he? Because he's not only has all of this occurred, he's trying to make a decision as to whether he accepts a settlement or not on something that he doesn't believe he should have to pay anyway. Then he gets a $3,500 bill from the law firm that's got him in this situation. And it's been calculated at an hourly rate of $300 for all work done and referred to the cost agreement signed by Trevor. Okay, so then it says, identify the following. What issues are raised by Belinda's conduct? What should the cost agreement and disclosure statement indicate? What remedies are available to Trevor? Okay, so this is a case where there's been a whole pile of failures, hasn't there? So can we outline maybe some of the general issues? What do you see as the general issues without getting into the nitty-gritty of any of them at this point? What are the general problems that have arisen here? What do you think?
Her handling of the matter from the beginning to the end.
Okay, so there's an issue of whether there's unsatisfactory professional conduct or professional misconduct. What else? What liability is there? What are the two areas of liability just under the common law? What are your two main common law subjects you do?
Negligence will be one of them.
Yeah, tort. Tort, yeah, negligence. What else? What's the other main area of common law? Contract. Breach of contract. So there's potential liability in tort and contract. There's also a potential liability in equity, which you may not have done yet. So there are fiduciary obligations which give rise to equitable remedies. In relation to the tort aspect, you're obliged to exercise reasonable care as a professional. What other issues are there? There's still more.
Well, I just had a quick look at the Australian Solicitors Conduct Rules, that she breached those as well.
Yeah, so that would come under the professional misconduct aspect. What about the whole firm's approach to supervising an employee lawyer? There's problems there. There's also the whole question of cost agreements.
With the supervision one, I had looked at that. I think it was section 56(1).
Yeah.
In one case, it's 18 months supervision.
Yep.
And in another case, it's 2 years supervision.
Yep.
So if she's only been there and she's in her first year, she's still subject to supervision.
That's right. She'll have an employee practicing certificate and she must work under the supervision of a principal lawyer. So there's all sorts of issues there. So that's in terms of an answer plan, they're the main sorts of issues to look at. So if we look, let's take some of those. Say the one about supervision. So she's a really junior lawyer. She's just starting out, so she needs to be supervised. She'll only have an employee practicing certificate. She's not going to have a certificate that's open, so she must be supervised in all the matters she does. So there is a principal lawyer there who has an obligation of supervision, which we haven't heard anything about. And they are in essence, vicariously responsible for her actions or inactions. So they carry the liability, and they're nowhere to be seen in the problem. What she's done could amount to unsatisfactory professional conduct under Section 418, or perhaps even professional misconduct under 419. It's possible. So both her and her employer have to exercise reasonable care, and they're liable in both tort and contract. And there's a case that you should mention. Astley, A-S-T-L-E-Y, against M Trust Limited, 1999, 197 CLR at page 1. So there's that. So she also has a fiduciary obligation in equity to act in Trevor's best interests, and her advice has been problematic all the way through. And her inaction in relation to filing the defence, having been instructed to do so, is, has jeopardised his legal rights to defend the claim, because the only way he could defend it is to go back and have that default judgment set aside, which she then failed. So he has, in effect, lost his remedy in relation to the first matter. There's nowhere for him to go other than to sue the lawyer, other than to sue Belinda and her firm. So she has been really negligent in relation to that default judgment.
I was just wondering too if he'd actually given her any instructions to do what she was doing when she went to court, because yes, he brought in the letter of demand and she saw that, but whether or not she actually took any instructions from him.
In the initial matter, she must have got some sort of instructions to give the advice, but I agree it's very nebulous, and that's not how you would set up the retainer agreement. That's one of the fundamental problems with this. But the month later, she actually stated that she's going to defend the claim. That's the one that really is problematic for her firm, because they didn't file the defence. Default judgment's then entered. They try and set it aside and fail. So the net result of that is that Trevor has lost his defence. So, he can sue that law firm. Belinda's and a law firm can be sued because he no longer can defend a claim, which he may have had a valid defence, but nothing was filed. So that's that's really getting towards professional misconduct. That matter in itself. All right. So with the retainer, when Trevor first went to see Belinda and received the letter of demand, you could argue that was the commencement of the retainer. You could argue that it ended once she gave the advice to ignore the demand, but it then became clearer a month later when he returns, and that's when she starts to do the sort of proper thing, where they start to set up the costs agreement. That should have been done earlier on. But anyway, so in terms of the cost agreement and disclosure statements, what the firm has to do is to comply with the requirements in Section 308. Now, we don't have a copy of the costs agreement, so we don't know fully whether they've done that. It's certainly dangerous if it's quite clear to you as a solicitor sitting there that your client is not reading the costs agreement. I would certainly write them a letter enclosing the cost agreement and saying that it's very important that they read it before they sign it. If they just, if they don't read it, then and you observe them not reading it, it's a real problem. They really need to have it emphasised how important the agreement is, and that they need to understand it and then sign it. Okay, now we don't know the contents of the disclosure notices or the actual agreement. We don't know whether, therefore, it complies with all of the elements in Section 308. So we'll just have to, assume that that's the case. All right. In terms of the remedies available to Trevor, he could seek to have the bill of costs. Remember, he was given a bill for $3,500. He could seek to have that bill of costs itemised. In other words, they have to give full details of how that's charged against the scale. You can do that under Section 332 of the Legal Profession Act. He can then seek to have that bill of costs taxed, or rather evaluated independently or costed independently, and to ascertain whether he's been charged correctly. He can challenge the costs agreement itself and say it's void under Section 327. He might argue that it's unfair and unreasonable. He might argue he wasn't properly advised. No defence was filed within the requisite time. And he could go through a whole process to have that set aside through the tribunal, the QCAT tribunal. Have a look at Section 328. In terms of disciplinary matters, it's possible that this can then, he can make a complaint to the Legal Services Commissioner or to the Commission. The Commissioner can, they've got summary powers. Have a look around about 432, Section 432. Can refer the complaint to the Law Society or could handle the complaint themselves. There's a natural justice element. The lawyer would be informed of the actual complaint. Commissioner has powers of investigation. The Commissioner has powers to start a disciplinary proceeding before a disciplinary body like QCAT. And QCAT, if that tribunal becomes involved, they can make a decision for compensation. Various enforcement orders can be made as well. So there's quite a few remedies that Trevor has in this situation. Then there's, of course, the common law remedy is there as well. But again, where you've got a common law remedy, you've then got to get another set of solicitors and barristers, and then you start arguing about that. And of course, you start incurring more costs, and the outcome is uncertain. It might be better to try and mediate or use alternative dispute resolution techniques to try and resolve this. The law firm, if it's sued, it will have professional indemnity insurance. And typically those insurers will want to try and settle a matter rather than having it drag on, building up costs and ultimately go to court, where it's going to cost a huge amount of money and there's uncertainty about the outcome. So, there's several ways of handling this matter. So I think the first way would be to try and mediate and resolve it that way through alternative dispute resolution. Aside from that, then, make a complaint to the Legal Services Commissioner and see if they'll progress it either through the Law Society referral or through the actual tribunal. So that's the sort of considerations that are involved in this question. Okay, so a client does have a few remedies. So I think the moral of all of this is, firstly, make sure you identify clearly where the retainer contract starts. Make sure that you actually have an appropriate costs agreement that's compliant with the requirements of Section 308. Make sure that's in place. Make sure that you're not negligent. And so you avoid all of these situations to begin with. Make sure, if you're a junior solicitor, that you're appropriately supervised. And make sure that you satisfy this continual obligation to make disclosure in relation to costs and generally do a good job. And if you send your client an account, make sure that what you're charging is reasonable under that cost agreement. So that's the sort of upshot of this situation. Okay, did you have any questions about this question?
I just really think the vicarious liability aspect of that firm in not providing the supervision and allowing first-year employee solicitors to work with clients and not follow the procedure. I think that would have been the thing that might have really been the crux of the matter.
If you were Trevor, I mean, it's likely that a first-year solicitor is not worth suing because they won't have much in term. One of the considerations if you're thinking about suing somebody is, are they worth pursuing? Is there assets? Can you get an actual recovery? Now that you've probably got more chance with the law firm, and they are vicariously liable for the actions of their employees. They fail to supervise.
Yep.
So they would be a better target in terms of trying to recover something. But I mean, you can do these various remedies. You can do multiple remedies at the same time. You could make a complaint under the, if you're Trevor, you can make a complaint to the Legal Services Commissioner in relation to this whole issue of them being negligent, and that amounts to professional misconduct, so that you've got a lot of misconduct proceedings happening. You can then try and seek a remedy that way through the tribunal as well. You could try and settle the matter, or you could even sue for breach of contract, or sue for negligence in tort as well, breach of fiduciary obligations as well. So you've got multiple remedies, and they're not mutually exclusive. You could do the whole lot if you wanted to. But you just got to remember going through the Legal Services Commissioner is not as expensive because you make a complaint. So that puts pressure on the law firm to resolve the matter, because they don't, they don't want a situation where that complaint progresses all the way through. If it can be settled and mediated, that's a better outcome for them. And they're in a very weak position here because they have done, they failed to supervise and all the rest of it. So if I was that law firm, I would be trying to settle this as quickly as possible. Because you really don't want these adverse outcomes coming, publicly reported as well. So it damages your reputation. But if a disciplinary complaint is made, you can't really stop that process. So you really want to try and calm the client down and resolve this issue before it gets to a complaint. Okay, does that all make sense? Are we happy with all of that? All right, look, that's it. That's that set of problems. There'll be another tutorial later in this week dealing with the trust accounting problems. Have a go at those. Have a go at the accounting. You've got very good resources on how it all works, but it does take a bit of effort on your behalf to come to grips with how you set out those accounts. But it is important that you understand those things. You're going to do it again when you do professional legal training, and again when you get out into practice. You'll need to understand trust accounting. Even if you work in a huge firm, it doesn't matter. The obligation is on you to make sure you understand the requirements under the trust accounting requirements. Okay, so it is actually a very important topic, and breaches of trust accounts is the single biggest area where solicitors get struck off. So it's a really important topic. Yeah,
just in looking at that, is it practice that it's manual or is it more electronic these days?
It depends on the size of the firm, but most of them would be electronic. But the electronic versions of this are only reflecting what the manual system does anyway. If you understand the manual system, you'll then understand the electronic system much better, because the manual system and the way we're doing it, it links it back to the rules so that you can see what your obligations are and what has to be in those accounts. And that's a better situation than just accepting what a computer system may shove up in front of you, because you need to think about these things. I don't know if you've ever used MYOB or any of those accounting packages, but if you don't know what you're doing, you can create a real mess with those electronic systems. you need to understand the underlying processes. So that's why I've gone to the trouble of working our way through some manual examples, because it slows you right down. It gets you to think about what things supposed to be there and how they relate to the rules. And in that way, if you're really clear on that, the chances of you falling foul of those things are really substantially reduced. And that's where you want to be. You don't want to be a practitioner who's not aware of these things and then continually makes trust accounting errors. Because failure to keep proper accounts is in itself something you can get struck off for. So it's quite important. Okay. All right, look, we'll stop there. Hopefully you'll come along to the Thursday evening session. I'll put this recording up onto the Moodle site, and I'll also put up the answer guides as well for these problems through to 16. If you have any questions or you think of something else that is troubling you, just send me an email or put it up on the Moodle site, and I'm quite happy to have a look at that. Now, I'll have some more details about your first item of assessment, which is coming up in, I think it's about week 6, and it covers weeks 1 to materials in weeks 1 to 5. So I'll give you some. I haven't written the actual quiz yet. So as soon as I write that, I'll then give you some details about how it's structured. Okay, but you'll have probably, I'd say, it'll be around about an hour in duration. And I think I'll probably have it over a 24 to, or maybe even a 48-hour period, so that you can start your 1 hour anytime over 2 days, depending, so it's a bit more flexible if you've got other things you've got to do. But I'll provide some more details about that. But you will need to understand the rules. So you need to have access to rules and all that sort of stuff. So you'll probably have to look up some stuff and make sure you can answer the questions. All right. Okay. All right. Look, we'll stop there. And I'll see you on, hopefully see you on Thursday. Okay. All right. Bye for now.
Thanks, Stephen. Bye.
Bye-bye.